The committee will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. The Oversight Committee exists to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is our mission. Today's hearing continues the committee's oversight of the IRS and its targeting of conservative applicants for tax-exempt status. The committee continues to conduct a thorough and comprehensive investigation of the IRS's targeting. From this oversight work, we know a great deal about the IRS's targeting. We know that in 2010, as the President traveled the country criticizing the Supreme Court's decision in Citizens United, the IRS began systematically scrutinizing and delaying tax-exempt applications. We know Lois Lerner talked about the political pressure on the IRS, and I quote, to fix the problem, again, to fix the problem caused by Citizens United. We know that Lois Lerner called conservative tax-exempt applicants, and I quote, very dangerous, and ordered them through a multi-tier review. And we know that conservative tax-exempt applicants faced enhanced scrutiny, extensive delays, and inappropriate questions and requests from the IRS. While there is much the committee knows about the IRS targeting, there is still much more work to be done. And for that reason, the committee continues its oversight. Today, however, we start the discussion of steps that can be taken to restore confidence in the IRS and ensure that targeting never occurs again. Our mission on the Oversight and Government Reform Committee is to make government work better for the American people. We meet today for that reason, to make the IRS work better for the American taxpayer. Our investigation has made it clear that one reform is absolutely critical to improving the IRS. We must get politics out of the IRS. To accomplish this, yesterday we issued a new staff report outlining 15 significant potential long-term reforms to stop abuse and get politics out of the IRS. Here are some of the ideas. First, the IRS should not be in the business of regulating political speech. When there is no impact on tax revenue. This process is where targeting happened. Other Federal agencies exist to regulate political campaigns and their elections, and this is not the IRS's job. This committee found it very frustrating to have to repeatedly remind members on the dais here that 501c4s, in fact, get no tax deduction, no special tax treatment, and that all contributions are post-tax. And yet, the IRS took special interest in who their contributors were, even though they were paying for it with money after they had paid their taxes. And Congress should consider changing that law. Second, the current structure of the IRS as a single director agencies allowed freedom to people like Lois Lerner and the exempt division to grow and gain power. It also created the circumstances under which White House was informed of Lois Lerner's lost emails months before Congress and the public knew. If Congress created a bipartisan multi-member commission, it would create assurances that the IRS truly is an independent, nonpartisan agency. Third, TIGTA, the special IG for Treasury IG covering IRS, and the IRS knew that groups had been targeted from May of 2012, but did not take immediate action to help the aggrieved parties. This was wrong, and this is the kind of inappropriate behavior that, again, affects the outcome of elections. We must examine the current structures of the Treasury Inspector General for Tax Administration and the IRS's Oversight Board to ensure that they are living up to their oversight responsibilities, not only to know, but to take action. Our report notes 15 problems and offers 15 solutions for Congress to discuss. I'm sure there are more good reforms and more good reform ideas that should be part of the discussion, and I expect some members to raise concerns with aspects that we have already suggested. Our investigation must also continue because we clearly do not have the full knowledge of what happened. We don't even have a significant portion of the emails from the most important figure in this investigation. Serious debate and discussion about reforming a failed agency and getting politics out of the IRS is a good and worthwhile exercise, even though there may not be any clear consensus for those major reforms today. Last week, the committee took bipartisan steps on some of these measures. As we develop future ideas, I hope we will continue to work in a bipartisan spirit. Our witnesses today will help us to explore the other steps that Congress can take to improve the accountability of the IRS. With an agency like the IRS, reform will not be accomplished overnight. This is an important process that will continue into the future and expand to many other committees and stakeholders. But this is a process we must start today. And from that standpoint, I want to welcome our witnesses, and I look forward to hearing their testimony. And I would now recognize the distinguished gentleman from Illinois, Mr. Davis.
Thank you very much, Mr. Chairman. Unfortunately, the ranking member, Mr. Cummins, could not be here today, and I'm substituting or sitting in for him. Today is the 12th hearing our committee has held on the IRS investigation over the past year. We've held 6 hearings on this topic in just the last 6 weeks. The IRS Commissioner has testified 3 times before our committee and a 4th time before the Ways and Means Committee in just the past month. The same is true for the organizations testifying here today. Representatives from all 3 groups, True the Vote, the Heritage Foundation, and the Center for Competitive Politics, testified before the committee in February of this year. I welcome our witnesses here today, or perhaps I should say welcome them back. Some may say our efforts are duplicative. It makes little sense, for example, to require IRS witnesses to submit to transcribed interviews with the Oversight Committee first and then force them to appear again before the Ways and Means Committee. But that is what these 2 committees on which I serve are doing. Unfortunately, one person who is not here today is Inspector General Russell George. The title of today's hearing is IRS Abuses, Ensuring that Targeting Never Happens Again. So it would have made sense to hear from the official who issued the report in 2013 that first identified inappropriate criteria used by IRS employees to screen tax-exempt applications. He could have told us how the IRS is doing in terms of implementing the recommendations in his report. Last week, Ranking Member Cummins requested that the committee invite the Inspector General, but he's not here today. Other people who are not here include progressive groups that were singled out. On April 17, 2014, Chairman Issa stated, and I quote, "There is simply no evidence that any liberal or progressive group received enhanced scrutiny because its application reflected the organization's political views," end of quote. But the committee has obtained substantial evidence that IRS employees treated progressive groups in a manner similar to conservative groups. For example, a Be on the Lookout list, or BOLO list from 2010, directed IRS screeners to look for, and I quote again, acorn successes. Another directed IRS employees to screen for, and I quote, progressives. A PowerPoint presentation from 2010 included images of a donkey and an elephant, and it instructed IRS screeners to look for the terms, I quote, progressive, alongside, and I quote again, Tea Party. And a training presentation listed successors to ACORN as examples of organizations to watch for. Witnesses also confirmed that progressive groups were subjected to extended reviews and delays. He stated that I am doing a transcribed interview with committee staff on October 29, 2013. A senior technical advisor in the Exempt Organizations Division testified that progressive emerged groups were subjected to multi-tiered reviews that included consolidating cases and working with attorneys in the Office of Chief Counsel. During a hearing before the committee on July 18, 2013, the Inspector General testified that he did not become aware of documents relating to progressive groups until after his audit was complete. He stated, I am disturbed that these documents were not provided to our auditors at the outset, and we are currently reviewing this issue. It is now more than a year later, and we still have not heard his update, and we will not hear today. Finally, late last night, the Chairman issued a Republican staff report with new recommendations for the IRS. This report was not provided to committee members in advance, so we did not have an opportunity to review it or offer our opinions. The primary recommendation is to eliminate the position of IRS Commissioner, one of only 2 political appointees in the entire agency, and replace it with a board full of political appointees. Personally, I was surprised by this recommendation because it seems to contradict the Republican narrative for this investigation. If you believe there is too much political activity at the IRS, I don't see how increasing the number of political appointees will help. I also wonder, given the committee's focus on over-politicized and dysfunctional boards at the Nuclear Regulatory Commission and the Chemical Safety Board, why this model is best for the IRS. With that, Mr. Chairman, I thank the witnesses very much for being here and look forward to their testimony.
Thank you. Members may have 7 days in which to submit their opening statements. I now ask unanimous consent that the aforementioned majority report, making sure targeting never happens again, getting politics out of the IRS and other solutions, be placed in the record without objection. So ordered. Additionally, I will add the previously published April 7, 2014 Committee on Oversight report debunking the myth of the IRS targeting progressives. Without objection, both will be ordered in. I might note for the record that we asked repeatedly for the minority to submit a witness. If they wanted the IG to be their witness, they certainly could have had them. Today we welcome our witnesses. Mr. David Keating is President of the Center for Competitive Politics. Thank you. The Honorable Hans von Spakovsky is the Manager of Election Law Reform Initiative and a Senior Legal Fellow at the Heritage Foundation. Ms. Cleta Mitchell is a partner at Foley and Lander, LLP, and Mr. James Schreck is the Senior Policy Analyst in Labor Economics at the Heritage Foundation. Thank you all for being here. Pursuant to our committee rules, would you please rise to take the oath? And yes, please raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record reflect that all witnesses answered in the affirmative. In order to allow time for discussion, please try to limit your testimony to 5 minutes. Your entire written statement will be made part of the record. We'll begin with Mr. Keating.
Mr. Chairman and members of the committee, thank you for the invitation to speak to you today, and thank you also for the investigative work you've done on this very important topic. Now, while the investigations here and elsewhere are still ongoing, and we don't know the full extent of what happened, we do know enough to make some recommendations already to ensure that nonprofit groups are never targeted again. I think the most important of these recommendations is to get the IRS out of the speech police business as soon as possible. Given the importance of First Amendment rights and the effect of tax compliance on revenue collections, the IRS is perhaps the last agency that we could envision as the speech police. As a revenue collecting agency, the IRS has proven that it's incompetent at regulating political speech, and that in turn undermines its primary function of collecting tax revenue. Its continued work in this area could cost the government tens or even hundreds of billions of dollars in tax revenue if a lack of trust in the IRS causes tax compliance to fall by even a tiny amount. Now, in fairness to the career staff of the IRS, this is very difficult work. As I like to tell people, campaign finance law is extremely complicated. It makes the tax law seem like a model of simplicity and clarity. Imagine, if you will, if we gave the Federal Election Commission the job of writing a tax regulation or enforcing the tax law. Well, the FEC would probably make a hash of it too. The IRS is simply not equipped, it doesn't have the culture, and it doesn't understand First Amendment constitutional rights. And the most important case in this area was the landmark Buckley versus Vallejo decision. In that ruling, the Supreme Court said, the supposedly clear-cut distinction between discussion, laudation, general advocacy, and solicitation puts the speaker in circumstances wholly at the mercy of the varied understanding of his hearers and consequently of whatever inference may be drawn as to his intent and meaning. Such a discussion offers no security for free discussion. In these conditions, it blankets with uncertainty whatever may be said. It compels the speaker to hedge and trim. And this is exactly the problem with the IRS guidance today for nonprofit organizations. This advocacy places nonprofit groups in, quote, circumstances wholly at the mercy and the varied understanding of his hearers, in this case, IRS agents. Now, the Court's solution was simple and elegant. And it essentially said that political advocacy was defined as communications that in express terms advocate the election or defeat of a clearly identified candidate. Shortly after this ruling, the Federal Election Commission came up with regulations to implement the decision. The IRS did nothing. Nothing. And as a result, it didn't recognize the Buckley decision, and it didn't modify its guidance in any way to reflect it. Congress recently, and I'm talking about in the last 15 years, has tried to move the IRS more into the area of political regulation, and this has embroiled the IRS in political fights the service should avoid. Given the history of the agency from the 1930s through the 1970s, where there was considerable history of presidents of both parties attempting to use the IRS to attack political enemies, the service has long been prickly, and justifiably so, about being dragged into political wars. Now, I'm concerned that this distrust of the IRS could lead to a fall of tax compliance. If tax compliance fell just 1 percentage point, the government could lose $170 billion in tax collections over the next 10 years. And that's why we think the solution is pretty simple, and that is to get the IRS out of the speech police business. We already have agencies in all 50 states, and we have the Federal Election Commission to regulate speech. And in fact, the IRS's own national taxpayer advocate, Nina Olson, wrote in her report last year, it may be advisable to separate political determinations from the function of revenue collection. Under several existing provisions that require non-tax expertise, the IRS relies on substantive determinations from an agency with programmatic knowledge. We already have such an agency. As I said, it's the Federal Election Commission. If the FEC decides if a group conducts excessive political activities, it can force and indeed has forced such groups to register and report to the FEC. If they are a political committee, then they automatically become a 527 organization and are no longer a social welfare, business, trade, or union. So I think that's the most important change that could be made. The IRS could and should do it on its own, and that is getting out of the speech police business, and that's the only solution, I believe, that can guarantee a similar scandal will not occur again. It will protect against a decline in tax compliance and help restore the agency's reputation.
Thank you. Mr. Von Spavos. Thank you. Spavkovsky.
That's it.
You know, and I grew up in a neighborhood with a lot of those names. I should be better. But if your name was Jasbinsky, I'd have been much more skilled in saying it. Thank you. Please, you're recognized.
Thank you. Mr. Chairman, I appreciate the invitation to be here today for your first hearing on how to fix the problems at the IRS, and that is how to prevent the IRS from abusing its tremendous power. In May of last year, Lois Lerner, as everyone knows, revealed that the IRS had been targeting Tea Party and other conservative organizations. This was apparently made public just before the public release of an Inspector General report that detailed the, quote, inappropriate criteria, close quote, used by the IRS to identify, review the applications of conservative organizations for tax-exempt status under 501c4 of the Internal Revenue Code. These reviews, again quoting the IG report, resulted in substantial delays in processing of their applications, and they were also subjected to voluminous requests for totally irrelevant documents and information. This represents one of the most dangerous actions that can be taken by a government agency, abusing its power to target disfavored individuals and disfavored organizations. What is worse is that the IRS seems to have learned nothing from this effort to regulate political speech, which is outside its statutory mandate, instead of sticking to its mission, which is collecting tax revenue. In fact, the IRS recently proposed new regulations that would, in essence, implement the inappropriate criteria that the IRS used in its unlawful targeting scheme. And unfortunately, as we all know, the IRS has a history of abusive behavior, starting with Franklin Delano Roosevelt, who used the power of the agency against a host of political rivals and business opponents. Now, I've got 6 recommendations that I'll make very quickly, although there are certainly others that we can discuss. First of all, I highly recommend the IRS be made an independent agency run by a multi-member commission. When compared to other Federal agencies like the FEC or the SEC, the IRS lacks the safeguards needed to assure citizens that tax regulation enforcement will not be used to stifle political opposition of the party in power. Specifically, for example, the FEC is an independent agency, and unlike the Treasury Department and the IRS, it is not directly accountable to the party controlling the White House. Additionally, the FEC has a bipartisan makeup of 6 commissioners instead of just 1. Since it takes 4 votes to carry out any action, it requires the consensus of both parties represented there to take any action. This reassures the public that the agency's policies, regulations, and enforcement decisions are based on the legal and factual merits rather than on partisan and ideological considerations. The IRS lacks both of these important institutional safeguards. The second recommendation is to place a time limit on the IRS's review of applications or eliminate the IRS review requirement entirely. Investigations revealed that at one point, for 27 months, the IRS did not approve a single tax exemption application from a Tea Party organization. This kind of years-long delay can be obviated with a time limit placed on the IRS for review, such as 60 days. That exemption could be granted then automatically if the IRS does not respond within 60 days. And you could even give the IRS the ability to extend that period once if it makes a written request for relevant information. Alternatively, organizations could be automatically granted tax-exempt status as soon as they submit a basic application to the IRS. That would prevent the type of manipulation that occurred. If the IRS later obtains evidence that an organization is abusing its tax-exempt status, it can then conduct an investigation or an audit just as it does for any other taxpayers when a problem arises. But there is no logical reason why the IRS should conduct a review of newly formed organizations just starting their activities. Third, the IRS should only be allowed to take into account political speech or activity that consists of express advocacy. Now, I actually agree with Mr. Keating that they ought to get out of this business entirely, but that is also something that should be considered. Also, the IRS has completely misinterpreted the definition of the promotion of social welfare, and this is my fourth recommendation. As you know, in order to be a 501c4, what the law says is you must be operated exclusively for the promotion of social welfare. The IRS has wrongly interpreted that term to exclude all political activity. However, in a democracy, political involvement and participation are within the definitions of social welfare. If you want to promote social welfare, it requires advocacy in the election process, given the broad and extensive scope of modern government. In today's America, you can't promote social welfare without interacting with government officials and legislators, as well as promoting the election of candidates with positions on issues that particular organizations believe are important in achieving their goals for promoting social welfare. I also think IRS employees should be held personally liable for certain violations of the law, which is not currently the effort. And finally, the IRS should be prohibited from using campaign finance reports or public disclosures of a taxpayer's political donations at the FEC as the basis for commencing an IRS investigation. Thank you.
Thank you. I now recognize Ms. Mitchell, partner with Foley and Lardner. Welcome, and you're recognized.
Thank you, Mr. Chairman, members of the committee. I want to thank you for conducting this hearing, but I also want to thank the committee and the chairman. I'm sorry he's not here for me to personally thank, and to thank this committee because you've been determined and dogged and relentless in trying to get to the truth. And from those of us, and particularly my clients who were on the receiving end of the IRS targeting, I can tell you that the IRS was determined and dogged and relentless in the denial of the First Amendment rights of hundreds of citizens groups and thousands of law-abiding, patriotic Americans. So my sympathy for the poor IRS being subjected to all of this investigation is not very high. You've asked us for recommendations about ensuring that this targeting never happens again. And I come before you today as somebody who has represented clients before the IRS for many years before the targeting started, represented clients during the targeting, and now represent clients in suing the IRS in 3 different lawsuits that are cases that have arisen from this unlawful targeting. And I want to say, first of all, that I believe that the IRS is such a corrupt and rotten and broken agency that it cannot be salvaged. And frankly, for that reason, I would urge the members of Congress to support Representative Jim Bridenstine's bill, House Joint Resolution 104, which would repeal the 16th Amendment, abolish the income tax, and by definition and extension, abolish the IRS, because I don't think this agency can be saved. But knowing that that takes a little while, in the meanwhile, I have 10 recommendations I'm going to go through quickly, which are things that Congress needs to do to reinstate the rule of law at the IRS, because that's what has been lost through all of this, is an abiding by the IRS with the rule of law. First of all, I believe that IRS employees should be prohibited from being unionized. They should not be in a political organization that gives 94% of its contributions to Democrats, including 11 members of this committee, all Democrats. No Republicans have received any contributions from this union. I think, number 2, that we should eliminate the application process for all 501c organizations other than C3s. There's absolutely no reason for organizations to go through this mother may I with the Federal Government to find out whether they can operate as a tax-exempt organization. They do not receive tax-deductible contributions. Contrary to what I hear constantly from members of Congress at these hearings, it makes my head spin. Contributions to a 501c4 organization are not tax-deductible to the donor. And there's no reason for organizations from any 501c category, all 29 of them, there's no reason for them to have to get permission from the government to operate. Number 3, define by statute that political activities are social welfare activities. We should be encouraging, not discouraging, the people from participating in political activities, and citizens organizations have a right and a duty to do that. Number 4, repeal the tax that is imposed on political expenditures by 501c organizations. It is a hateful violation, in my view, of the First Amendment to tax citizens groups for the exercise of their First Amendment rights. Number 5, this one needs a lot of work. Congress has got to take Section 26 U.S.C. 6103, which was enacted by Congress to protect taxpayers from unlawful inspection, release of their tax information. The IRS has turned it on its head and now uses 6103 as the basis for denying the rights of citizens and taxpayers, denying Congress access to information about misdeeds by the IRS. We need to give taxpayers a private right of action and opportunity to recover treble damages from individual IRS employees who violate their 6103 rights. We need to repeal, number 6, repeal the requirement that organizations must reveal to the IRS their donors. That is a terrible law, and it has given rise already. The first inkling we had of IRS targeting of conservatives was when we saw the IRS going after donors to a conservative group and tried to impose a gift tax on them. There is no public interest and no public policy imperative for citizens to have to disclose to the government who their donors are. These are not public documents, and they should not be subject to being disclosed to the IRS. Number 7, as Hans said, we must, and I think the committee should expand its investigation and investigate, because I'm absolutely convinced that the IRS has used campaign finance reports, and in particular donors to the Romney presidential campaign or super PAC, as the basis of conducting personal IRS tax audits. And I think that that should be illegal, but this committee needs to get to the bottom of that particular situation, because I have heard too many stories from too many people from all over the country to not think that something is afoot there. We need to give number 8, a private right of action to citizens to be able to go to file lawsuits and to recover damages for the violation of their constitutional rights by federal employees, just as they can today against state and local employees. That should be extended to federal employees. Number 9, we have to reaffirm, Congress should reaffirm that the laws that Congress has enacted to protect taxpayers and citizens from an overreaching federal government in fact apply to the IRS. I have listened and watched and read the IRS say that things like the Administrative Procedures Act, the Regulatory Flexibility Act, the Paperwork Reduction Act don't apply to them. And we've seen that the IRS has completely disregarded its statutory obligations under the Federal Records Act and the Federal Information Security Management Act, and they're making a joke out of FOIA, because now they either don't answer your questions, make you sue them, or they lie. And finally, that we should make a law. The 18 U.S.C. Section 1001 makes it a crime for any citizen to make a false statement to a federal agency, agent, or investigator. Well, I believe that the IRS and its employees and federal employees should be held to the same standard when they lie to us. The IRS Commissioner, Doug Shulman, came before this committee in March of 2012 and told this committee that there was no targeting of conservative groups, and that was a lie. And what has happened to him? And Lois Lerner has lied. Other members of the IRS, they've lied. And I think that they should be subject to the rule of law, and all the laws that Congress has enacted that apply to everybody else ought to apply to the IRS. Thank you.
Thank you for your testimony. We'll now turn to our final witness, Mr. James Shirk. He is a Senior Policy Analyst in Labor Economics at the Heritage Foundation. Welcome, and you're recognized, sir.
Representative Mica, Representative Davis, and committee members, thank you for the invitation to testify. My name is James Shirk, and though I work for the Heritage Foundation, my testimony this morning should not be construed as an official position of the Heritage Foundation. This morning I want to explain to you that the law makes it very difficult to fire federal employees, and that this shelters workers who engage in misconduct. Congress should streamline the firing procedures to discourage employees at the IRS and at other agencies from abusing their positions. There are 3 facts about the current civil service system that Congress should understand. The first fact is that trying to fire a federal employee takes years of effort. Agencies can remove workers. However, even after severe misconduct, doing so takes incredible time and effort. An agency must show that a reasonable person would more likely than not conclude that the evidence justifies a firing. Gathering the evidence to show this can take months. Then the agency must give the employee 30 days advance notice before removing them. During this time, they cannot hire a replacement and must pay the employee. If the employee during this time alleges that their supervisor is firing them for exposing misconduct, they can ask for a whistleblower investigation, during which time they also cannot be fired, even if it's a completely baseless investigation. After all this, the agency can remove the employee. However, the employee can appeal their firing to the Merit Systems Protection Board, or MSPB. In 2013, this initial appeal took an additional 3 months. If the employee loses this appeal, they can then file a second appeal to the MSPB headquarters in Washington. In 2013, this second appeal took an average of over 9 months. If the MSPB rules against the employee again, they can appeal then to the EEOC or to the federal courts. In total, it can take several years to fire employees for even flagrant misconduct. For example, it took the Treasury Department 5 years to fire Lester Erickson for lying to investigators during an internal misconduct investigation. For many managers, successfully removing a problem employee becomes a full-time job in its own right, and doing nothing is, unfortunately, often the path of least resistance. An Office of Personnel Management study found that managers feel it takes, quote, heroic, unquote, efforts to remove problematic employees. The second fact is that this causes federal employees to rarely lose their job, sheltering those who abuse their position. Most federal agencies are not run by heroes. They're run by managers trying to operate the government. An OPM survey found that only 8% of managers with poorly performing employees attempted to remove them, less than 1 in 10. And of those who attempted to do so, over 3/4 reported that their efforts had had no effect whatsoever. So unsurprisingly, the statistics show that federal employees rarely get fired. OPM data also shows that last year, the federal government fired less than 10,000 workers out of its 2.1 million man workforce for discipline or performance reasons. Almost half of those firings occurred among new hires in the probationary period. Last year, the government fired just 0.25% of tenured employees with 2 or more years of experience. Now, employees who engage in misconduct know how hard it is to remove them. The Office of Personnel Management reports that many managers stated in their agencies, quote, the unwritten policy was to avoid any situation that could lead to an appeal or lawsuit, unquote. In other words, managers frequently let misconduct slide. For example, at the Department of Housing and Urban Development, an employee spent over 1/3 of his time, over the course of 5 years, conducting private business deals using his official email account. One of those business deals involved providing a lap dancer to a private party. HUD officials do not even try to fire him. And this system also shelters the IRS employees who target Americans for their political views. IRS employees have the same notice and appeals process as other government workers. Consequently, IRS managers had and still have strong incentives to ignore employees targeting Americans for their political beliefs. It would take heroic efforts to remove employees engaging in such conduct. Now, the third fact is that Congress can fix these problems by reforming America's civil service laws. Ideally, Congress should return to the spirit of the original Pendleton Act, which regulated the hiring of federal employees to prevent a political spoil system, while allowing managers to remove employees at will. Congress should return to this policy and make federal employees at will, while still preventing patronage and nepotism appointments in the hiring process. Barring such reform, Congress should at least streamline the firing process so it takes less time and effort. Congress can take several steps to do so, such as allowing federal managers to immediately suspend employees without pay when they've engaged in misconduct, and then providing the due process after their suspension. Congress should also eliminate the ability of federal employees to appeal their dismissal through multiple forums. They should have to pick one. Congress should also extend the probationary period from 1 to 3 years to give managers more time to vet employees and remove those likely to cause problems later. And to encourage good behavior, Congress should transform the current seniority-based step increases into performance-based raises. Thank you. I appreciate the opportunity to explain that the law makes it very difficult to fire federal employees and that this shelters workers who engage in misconduct.
I thank you, Mr. Shirk, and the other witnesses for their testimony. Ms. Mitchell, unfortunately, you seem to be very wavering in whether you think we should do something about IRS, but all humor aside, it sounds like you represented some people who also were targeted, and maybe you could tell us a little bit more about, again, about what you've seen and people. The other thing, too, is these people, if you're defending them, you're the attorney, who's absorbing the cost, what's this doing to their lives? Now, we're here to look at a remedy, but I think it's also important to look at the impact, and you are by far one of the most forward speaking people about the damage that has been done by IRS that we've had before our committee. So would you mind commenting?
Well, I'm happy to do that, Mr. Chairman. I testified in February before Mr. Jordan's subcommittee, and I told this story, but this wasn't the full committee. I represent people who apply for tax-exempt status, and I've been doing this for many years. I've been dealing with the IRS exempt organizations unit for many, many years, representing groups seeking tax-exempt status of various kinds, C3s, C4s, C6s. And it used to take, prior to the onset of this scandal, to get a 501c4 application reviewed and processed would take 3 to 4 weeks. I had an application I first began to realize something was going on at the IRS in early 2010 because I had a client, we applied for tax-exempt status for a 501c4 group in the fall of October 2009, and the IRS cashed the check, because you do have to pay for this privilege, and then we didn't hear from them again until June of 2010. And this was very unusual. This had never happened before. And in early 2010, and then I had another application that we filed. And
how long before, you said 2010, how long before were you handling these kinds of cases?
Oh, decades.
So,
yeah, I mean, this wasn't.
This was quite a departure from.
It was a total departure.
Total departure.
It was a total departure. And by the way, that organization that filed for tax-exempt status in October 2009 did not get its 501c4 tax status granted until July of last year, and only after this committee, the scandal broke and this committee began its work. And so, I mean, I represented a number of organizations that applied for tax-exempt status during that period and were associated with, they were conservative or Tea Party groups. They were groups that were opposing Obamacare. And I really do believe, frankly, that that is one of the triggers. We don't know all the information that you know and that your investigators know, but I think one of the criteria that the IRS was looking at was whether these organizations were opposing Obamacare as a matter of policy. And now you have a situation, I think it goes to my colleague's testimony, which is that when you have an agency that now not only is collecting taxes, but is the agency that is enforcing Obamacare, and now it's regulating political activities, you're mixing things that should not be mixed in an agency that is set up to collect revenue.
Did you have any progressive groups also come to you with?
Well, it doesn't really work that way. And the fact is, it's like, I mean, you got to choose. You're going to play for USC or Notre Dame. You can't play for both. Oh. And people have lawyers who, or in our case, the University of Oklahoma or Oklahoma State. I see my congressman from Oklahoma City, which is where I'm from.
The future senator.
My future senator, yes. But Republicans have lawyers and Democrats have lawyers. They represent them because, and same was with.
Well, were you aware of? I mean, the accusation is that.
I'm well aware of that.
That this was also a target towards progressive groups. Now, I just asked the staff. There was one of the principal promotions. What was the name of it? Organizing for Actions, I think it was approved in 73 days, and 27 months there was a freeze on conservative groups. It doesn't appear to us that the other side was targeted.
We're not targeted.
And let me say this too: if you were targeting progressives, if this was all about progressives or liberals, the ceiling would be coming down,
yes,
and there would be riots in the street. But
well, Mr. Chairman, if you look at the documents, I mean, I know that this is something that the minority members of this committee and the House keep saying, but it simply isn't borne out by the facts. If you look at the documents, frankly, that have been posted by Congressman Levin on the Democratic Democrats, the minority pages of the Ways and Means Committee, he has posted a lot of documents from the IRS, and he posted it to stand for the proposition that progressives were referenced just the same as Tea Party groups in these monthly reports. And I've read the training materials to which Mr. Davis refers. But if you read what they said in the training and you look at what the instructions were, here's what the instructions were for progressive groups. You look at those, yes, they were on a BOLO list, but if you found them, what the instructions said was, there are some progressive groups who have applied for 501c3 status that is more appropriate to tell them to be C4s. If you look at what it said for the Tea Party groups, it said send them all, basically quarantine them in a special unit in Cincinnati. And that's the difference. Yes, they looked at them, but they looked and got different treatment depending on whether they were progressive or Tea Party. If they were Tea Party, they literally were quarantined for a period of years. The progressive groups were looked at to make sure they'd applied for the right status, and then they got their tax status. That's the difference. And in the case of many of these conservative groups and Tea Party groups, the Tea Party of Albuquerque still hasn't gotten its tax-exempt status. And there are many of these small groups, when they got these letters from the IRS, saying, tell us everyone who's spoken at your meetings, tell us everybody who's on your board, who are your volunteers, how many volunteers do you have, what are their names, who attended your meetings, do you have transcripts of of everything they said when they spoke to you, tell us everywhere where your president spoke in the last year and where she plans to speak in the next 2 years. These are impossible questions, and a lot of these groups, when they got these very burdensome letters from the IRS saying things like, did you have candidate debates, did you do voter registration? And I had people saying, were we not supposed to do candidate debates? Are we not supposed to conduct voter registration? Because they think if the government's asking them those questions, that maybe they were doing something wrong. And so what did they do? They started backing away. Many times groups just went away because they couldn't get contributions, because they didn't have their tax status, and it had the desired chilling effect. And that viewpoint discrimination caused injury to hundreds and hundreds of organizations nationwide.
And gagged a particular viewpoint prior to a national election. Mr. Davis.
Thank you very much, Mr. Chairman. It seems to me that the logical place to start this discussion is with the report issued by the Inspector General in May of last year. And it is my understanding that Mr. Cummins did ask that the Inspector General be a part of this hearing. The Inspector General found that IRS employees in Cincinnati developed what he called inappropriate criteria for screening applicants for a tax-exempt status. He also identified serious deficiencies by IRS managers. He found that Lois Lerner was not aware that these employees were using these criteria for a full year. He also found that even though she ordered an immediate stop to them, the employees used different inappropriate criteria anyway. Since then, the committee has obtained evidence that progressive groups were also singled out in similar ways, being listed expressly in so-called be on the lookout or BOLO lists, receiving lengthy questionnaires, facing long delays, and sometimes being denied. I agree that no groups, conservative or progressive, should be singled out based on inappropriate criteria. In his report, the Inspector General made 9 recommendations for reform at the agency. Ms. Mitchell, let me ask you, in your opinion, how do you think the IRS is doing in implementing these recommended reforms?
Congressman, I have to tell you in all honesty, I think the application process is completely broken. It is Humpty Dumpty, it is off the wall, and it cannot be put back together again. What the IRS has done subsequent to the TIGTA report is to make matters worse.
Well, then let me ask our other witnesses.
Can I give you an example what
Yeah.
they've done? Because they issued those regulations the day after Thanksgiving, which had clearly been in process for many months, if not years. I think this committee released an email from Ruth Madrigal from the Treasury Department to Lois Lerner that was dated, I want to say maybe even 2011. And so they've been working on regulations off-plan, not in public view, which they sprung on the American people over the Thanksgiving holiday and gave us until February 28 to issue comments. And there were over 160,000 comments. I want to tell you that some of us worked pretty darn hard to get those comments filed. And what those regulations would have done would have codified the egregious, horrible principles that were in all of those, quote, development letters that were sent to the conservative groups in 2010.
Okay.
But
Our
since
time
then,
is running, so
I know,
let me
but I want to
just-
tell you one more
Let me
thing.
just ask the other witnesses what their opinions are. You have?
I think one of the recommendations was for the IRS to come up with clear rules, and I think the IRS, as Cleta indicated, their proposed rulemaking was horrible. We did a study of all the comments filed, and the opposition was almost unanimous. And you had groups left and right, business and labor unions were unanimous in their criticism of the agency's rules. So I don't think the IRS gets it. I don't think they understand the First Amendment, and that's why I think the key recommendation is the IRS should get out of the speech police business. And this is something that the National Taxpayer Advocate, an independent voice inside the IRS, Nina Olson, she actually has a background in low-income taxpayer compliance and advocacy, and she came to the same conclusion, and I think it's something the IRS should do.
Congressman Davis, I'll just make one comment on that, and to show you just how confused the IRS was. These new regulations they proposed, they were all in essence to have what their definition would be of campaign-related activity. Well, their definition of campaign-related activity would completely conflict with the Federal Election Commission's definition of campaign-related activity. So things that the FEC thinks are just fine and are not campaign-related, the IRS would say, no, 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 those are campaign-related, which would put all kinds of organizations in this untenable position. And these regulations were so bad that I and 7 other former FEC commissioners wrote an extensive public comment pointing out all of the basic errors and mistakes that the IRS had made with these proposed new regulations.
And let me just hear from Mr. Shirk.
Representative, it would take an act of Congress for the IRS to be able to streamline their firing procedures. I mean, there's some internal agency regulations, but the core of it is mandated by Congress in Chapter 43 and Chapter 75 of Title V of U.S. Code. And unless Congress acts, they can't do much to make it easier to remove people quickly for misconduct.
Thank you very much, Mr. Chairman. And I assume we're going to come back, and I've got some other questions I'd like to raise on that.
So we've had 12 hearings, and you still have questions. I appreciate that, Mr. Davis. Mr. Jordan.
I thank the Chairman, and I want to thank our witnesses for being here today, but more importantly for all the work they have done in helping let the American people know what the Internal Revenue Service was up to, what they did, how they harassed people and targeted people for exercising their most fundamental right, their right to speak out in a political fashion against their government. Let me just dispel one thing. 104 to 7. Those are the numbers. 104 conservative groups we know were targeted, harassed, delayed. 7 progressive groups were put on a different list, as Ms. Mitchell pointed out, put on a different list, got their C4 status, and never received anything close to the same kind of treatment. So this idea that it's wrong, it's false, it is just simply not borne out by the facts. The idea that the IRS is involved in way too many things, of course. Mr. von Spakovsky, they're not the FEC, for goodness sake. They can't enforce election law. They shouldn't be involved in health care law, of course. And the rule that Mr. Keating just brought up, we had a hearing several months ago where we had the ACLU, Tea Party Patriots, Motorcycle Association of America, and Homeschool Legal Defense Association, all opposed to the rule. Now, when you have the ACLU and the Tea Party and homeschoolers and Harley riders all against the same thing, you know that this is unbelievable. And the thing I want to get to the question and just get your response on, because I know we have people with a background. There's another hearing going on. That's why you see a lot of members over at the other hearing dealing with this special prosecutor resolution that passed Congress with 26 Democrats, I might point out. Every single Republican, 26 Democrats supported a resolution saying what the Justice Department is doing in their investigation here warrants an outside special counsel. And so I want to get your thoughts on that. And let me just prompt you with one thing. 2 weeks ago, we had James Cole, Deputy Attorney General, the #2 guy at the Justice Department, James Cole, sitting right where you're all sitting. And we asked him a pretty basic question. When did you learn, when did the Justice Department learn that the Internal Revenue Service had lost Lois Lerner's emails? And his response shocked us all. He said, we learned when it was reported in the press that they'd been lost. Even though, sitting at that same table a week ago, Mr. Koskinen told us he knew in April and his chief counsel knew in February. And the Justice Department learned June 13th, when the rest of America learned that they had lost Lois Lerner's email. So I want your thoughts on, do we need a special counsel? I'll just go right down the list, but particularly Mr. von Spakovsky and Ms. Mitchell, who I know have had a background in dealing with this. But let's start with Mr. Keating.
I think that would be advisable. I think I first suggested that. I wasn't the first to suggest, but I first suggested that last year, shortly after the scandal broke.
Thank you. Mr. von Spakovsky, if I'm correct, you worked in the Justice Department.
I did, and I frankly was astonished at Cole's answer for this reason. In May of last year is when Attorney General Eric Holder announced that he was opening up a criminal investigation of this. Well, I was involved in investigations of the Justice Department. The first thing you would do, if you have the FBI as your investigator in a situation like this, is go and seize all of the documents and information the way the FBI does when they're investigating a private organization. A year and a half later, they clearly had not done that and didn't even know that all of the evidence they were supposedly supposed to be looking at, all these emails, didn't exist.
And when we asked that specific question, did you get a court order, did you get a warrant, did you go to Lois Lerner's office, did you grab all the documents, did you get her computer? Of course, they hid behind, well, there's an ongoing investigation, we can't comment. But based on witnesses we have had in depositions and transcribed interviews, it sure seems like they haven't, and based on the response, it sure looks like they haven't.
No, I don't think they've taken the most basic steps you would take in a real investigation.
Yeah. Ms. Mitchell.
Well, I don't think there's any question that there should be a special prosecutor. You know, the problem is that the longer they wait, the harder it is to conduct an authentic investigation because of the spoliation of evidence, et cetera. We filed a motion in our civil suit. True the Vote sued the IRS and a number of individual IRS employees for the denial of its First Amendment rights and the consideration of its application. And so we filed 3 weeks ago a motion for a preliminary injunction asking the court to conduct an evidentiary hearing into what has happened. And that motion is pending. We had a hearing, and we are waiting. Then the judge ordered the IRS to file 3 declarations that are supposed to be first-person authentic evidence. And, you know, and the Justice Department told the court that this is in the civil case.
Yeah. Mr. Shirk.
That they didn't know.
Yeah.
Until they read it in the paper.
It certainly seems that such an investigation would be warranted. But even if you had a special prosecutor who brought charges against the IRS, individual IRS employees, it would still take the agency months to remove them. In many cases, to be collecting pay.
Mr. Chairman, if I, are we given a little extra time here, Mr. Chairman? Or? No one objects. Okay. Well, I'll wait till the second round. I don't want to do that. I know we got other folks. Thank you, Mr. Chairman.
That's better. The gentlelady from Illinois, Ms. Kelly.
Thank you, Mr. Chair. Mr. Shirk, in April, our chairman made this statement, and I quote, "There is simply no evidence that any liberal or progressive group received enhanced scrutiny." Do you agree with that statement?
I'm an expert on the firing procedures and Federal workforce. I would defer to the others on the panel who have more expertise in the specifics of the targeting.
So you have no opinion?
I would certainly give the chairman always the benefit of the doubt, and I would assume it would be accurate. But if you'd like to talk to me about ways we can fix how the civil service laws, I'd be happy to answer those questions.
Well, I'd like to go through some of the evidence our committee has obtained during our investigation. These should be simple yes or no answers. First, we received a copy of a so-called BOLO list from November 2010 that directs IRS employees to screen for progressives. It states, and I quote, "Common thread is the word progressive. Activities appear to lean toward a new political party. Activities are partisan and appear anti-Republican." Were you aware of that document?
I'm aware, to the extent I've heard it discussed, that there was at this hearing that there was differential treatment between the two groups. But again, my focus and my expertise is on labor policy and on the Federal civil service laws.
Well, let me go on. Another BOLO list from August 2010 directs IRS screeners to look specifically for ACORN successors. Were you aware of that document?
I was not aware of that, although, as Representative Jordan pointed out, it was something like 104 to 7 was the differential treatment between groups on the right and groups on the left.
Well, also, there were probably more Tea Party groups that applied, so you probably would have some differences. A BOLO list from February 8, 2012 includes an entry for Occupy organizations. Were you aware of that document?
No, I was not, but I wasn't looking for it. Again, I was looking into Federal firing procedures.
Just yes or no is fine. A PowerPoint presentation from 2010 includes images of a donkey and an elephant and instructs IRS screeners to look for the terms progressive alongside Tea Party when reviewing tax-exempt applications. Were you aware of that document?
That's not something I'd looked into because, again, my expertise is on the Federal civil service laws.
Thank you. Notes from an IRS screening workshop in 2010 list emerge, quote-unquote, groups alongside Patriot, quote-unquote, and 912 organizations. Were you aware of that document?
Again, as with all your questions,
you can just
that's
say
not
yes
the
or no.
focus. No, I was not, Representative.
Progressive groups were sent lengthy questionnaires almost identical to the ones sent to Tea Party groups, and they also had to wait years to receive tax-exempt status. For example, a Palestinian rights group in Minnesota received inquiries that were almost identical to those sent to conservative groups and waited more than 2 years for final IRS tax-exempt status approval. Were you aware of those questionnaires? Just yes or no?
No, I was not, Representative.
Okay, thank you. How about witness testimony? Our committee interviewed witnesses who testified that progressive groups went through a multi-year, multi-tiered IRS review process, similar to that used for conservative groups. For example, during a transcribed interview with committee staff on October 29, 2013, a senior technical advisor in that tax-exempt government entities division explained that, like Tea Party organizations, emerged cases were grouped together and subjected to a lengthy multi-tiered review. Were you aware of that testimony?
No, I was not, Representative.
Many people point to the number of Tea Party cases that were screened as evidence of bias, but the simple fact is that there were many, many, many more tax-exempt applications during this time frame from Tea Party groups. And it's really time for us to stop politicizing this issue. People on both sides of the aisle in this room, we don't want bias and discrimination and wrongful treatment against any group. We just want to get to what the fact of the matter is and make sure that each group is treated fairly. And I might add that the IG said that he was not aware of the BOLOs for screening progressive groups before his audit was released. That's why the report was skewed. And I wish the IG was here to actually answer questions about this. I yield back.
I thank the gentlelady. You have only your ranking member to complain to for not asking for the IG. Is there anyone else that would like to answer that question or comment, since Mr. Scheck, quite frankly, was probably the worst person as far as any looking at those questions? Ms. Mitchell?
Mr. Chairman, I've seen most of those. I've reviewed most of those reports to which the Congresswoman was referring. And those training materials from July of 2010 specifically state progressive does not equal Tea Party. That's in the outline, that's in the minutes of that training session. And yes, they were looking for that term, but they were looking for the term and given different instructions as to what to do if they saw it. And I'll give you an example. There's an organization called Progress Texas.
The gentlelady might want to remain. This is still your time and answers to your questions. I understand. Continue, please.
There is an organization called Progress Texas, and in a report that was leaked to USA Today in September of last year, this was a November 2010, maybe 2011 report of the IRS, and it was a sensitive case report, and it had, I think, 162 cases on it, and it did have some progressive groups. But what happened was Progress Texas, when it had the comments about Progress Texas, it said, seems to have anti-Rick Perry propaganda. And within 6 months, they had their tax-exempt status, or C4 status, compared to my client, King Street Patriots from Houston, where it said likely approval. You know when they got their 501c4 status? December of 2013. They just got it. And we got another round of questions last August after the scandal broke. So yes, progressive groups, the word progressive was on some of those reports, but what the IRS employees were instructed to do when they saw that term was totally different from what they were instructed to do when they saw a Tea Party, 9/11, or other conservative group.
I thank the gentlelady for making the answers complete, and I hope MSNBC will broadcast both. We now go to the gentleman from Oklahoma, Mr. Langford.
You are an optimist on that, Mr. Chairman. I do have a couple follow-up questions. The specific goal of this hearing is to be able to determine how do we keep this from happening again. Now, there are several comments that have been made, and I appreciate all of your written statements and your oral statements as well to be able to walk through this. Probation changes. Mr. Shirk, you mentioned this as well, changing the probation, extending that. You made a brief comment on that. I'd like for you to expand on that from 1 to 3 years for new employees so we can deal if there's a problem early, we can discover it early. What's the difference on trying to be able to deal with discipline for an employee in their probation status versus once they've been there?
Thank you, Representative. For the first year in most agencies, and some agencies it extends to 2 years, employees are called basically probationary. And they can be fired almost at will. There's only 2 reasons you can't fire them during the probationary period. One is for political discrimination, so you can't say you're a Republican, you're a Democrat, get out of the Federal service. And the second is on the basis of marital status. For any other reason beyond those 2, they can be fired. And fairly large numbers of them are. Again, if you look at the figures for terminations for layoff and performance in the Federal Government for last year, almost half of them came from employees with less than 2 years of experience.
So is that something you would recommend government-wide, or are you recommending that simply for the IRS?
I'd recommend it government-wide. Give the managers more time to review the employees and get rid of people they think might cause problems later.
Okay, thank you very much. Ms. Mitchell, thanks for being here as well. We can speak Okie to each other back and forth off the dais as well. But the second recommendation you had, eliminate the application process for exempt organizations other than 501c3 entities. Stop them other may I. Can you go into greater detail why that would matter? There are lots of folks that come in and say if they're going to be tax exempt, they're quote-unquote getting Federal funds, and so they should be limited.
Well, that is simply not true, and it demonstrates a lack of understanding of how the process works and the end result when you get a letter of determination from the IRS. And I recall that when this committee had then IRS Commissioner Shulman appear before it in March of 2012, and when he lied to the committee and said there was no targeting when there was, the other thing that he said at that hearing was, well, you know, 501c4 organizations don't even have to have a letter of determination from the IRS in order to operate as a 501c4. So, but if they submit themselves to our jurisdiction, we can ask them whatever we want, which I thought was a pretty arrogant comment, frankly. But anything else you do, and if you want to open any kind of entity, if I want to open a flower shop, if I'm going to be my mother's estate executor, I have to open a bank account. I file a form with the IRS. I tell the IRS what it is that the entity is going to be, and then I just start operating, and I file the correct tax return, and the IRS deals with it after the fact. And one of the problems here with the 501c4 screening process that they employed was that they started trying to conduct program audits during the review process, the application review process. They completely abandoned their published rules and application and all. 501c3 is the only organization, the only type of entity that offers a benefit to the donor, that you give money to it and you get a tax deduction. Every other 501c group is, as the chairman pointed out, receives contributions after tax. So there's no reason to have all of this process in the first place. Just get rid of it.
Right. What about the publication of donors and submitting the list of donors to the IRS?
Every tax-exempt organization has to file a Schedule B with its Form 990 tax return, in which it must disclose to the IRS all donors of $5,000 or more. Now, that is not a public schedule. The public is not entitled to it. It is by law confidential. So the only people you're telling the information to is the IRS. And since, as I said, for all organizations other than C3s, I mean, I would probably get rid of it for C3s because I don't really see the point. But if they can make an argument that they're in a different category because contributions are deductible, but there's no public policy reason to tell the government who has given of their after-tax dollars.
Are they cross-referencing that to the individual's tax returns?
Well, there's no reason to, because they don't get any tax benefit.
So that is the question then of why do you gather that? That limits the authority. The IRS typically functions in the gray areas of the law, and that's where they have the greatest amount of power. You had also started a comment earlier telling a story about the new rulemaking, and you were giving an example that we'd run out of time on. Can you finish that story briefly?
The day that, thank you, Congressman, the day that the comments closed was February 28th of 2014, and at last count, I think it's over 160,000 comments. The following Tuesday, that was on a Thursday, the following Tuesday, March the 4th, the IRS issued new guidance for reviewing applications for exempt status for 501c4s. Guess what's in that guidance? It is all of the questions, many of the questions that they were trying to include in their new definition of candidate-related political activities are now in their guidance as to the kinds of development letters and questions that every 501c4 organization can anticipate receiving from the IRS if you file an application for C4 status going forward. I just will tell you from a practitioner's point of view, I think it is malpractice if I ever submit another one of those applications to the IRS until we get rid of it. So I just think the whole process is completely broken, and it just needs to be eliminated.
Okay. Thank you. I yield back.
Thank the gentleman. We go to the gentleman from Nevada, Mr. Horsford.
Thank you, Mr. Chairman, and to the ranking member. Thank you to the witnesses who are here today. Let me begin by saying, as I have said before, I think this is probably over our 15th hearing or something like that on this issue. I am not a defender.
The gentleman wasn't here, but it was noted by the ranking member. It's the 12th.
Okay. 12, 15, they all kind of run together when it's the same regurgitated issues with no resolution. I'm not a defender of the IRS. I'm a defender of my constituents who want there to be accountability. I believe that there was wrongdoing by individuals, staff-level individuals, and part of this committee's oversight and government reform function should be to get those facts and to address those concerns. I am not here, nor do I care about how this hearing plays with MSNBC or Fox News, because it's the constituents back home and their opinion that matters to me most. So I have one question for each of you, and I would ask you to be brief so I can tackle another issue that I'd like to put on the record, and that is this title is IRS Abuses, Ensuring that Targeting Never Happens Again. So what is one concrete suggestion that this committee should act on in order for the targeting that did occur, the IRS wrongdoing that did occur, can be addressed? Each of you, if you could limit your comments 1 suggestion.
Well, my one suggestion would be to do what Nina Olson, the National Taxpayer Advocate, the independent ombudsman inside the IRS, recommended, and that is to get the IRS out of the business of making political determinations about speech. And this is something I think the committee should encourage the IRS to do. It already has the authority to do, and it has other agencies to make these determinations, and the IRS wouldn't have to do anything further.
Thank you.
Congressman, I have to agree with that, and that is something that all organizations, I don't care whether they're conservative, liberal, or moderate, all of them should want that the IRS not be looking at and analyzing the speech and activity they engage in to determine whether they think it's political or not.
So is your point that some other entity should perform that function and that determination?
No, it's just that the IRS has the wrong definition that it uses when it looks at 501c4s. I detail this in my testimony, but basically they've misinterpreted the law in a way they shouldn't be doing to use that against organizations, and they simply should not be doing that.
Thank you.
Well, when you have 10 children, I just recommended 10 things. I've got to pick my favorite. So if you want to be sure that there's no targeting of citizens groups, you eliminate the process of having to ask the IRS for permission to operate as a citizens group. Just eliminate that application process altogether, and then you won't get into a fight about whether it was progressives or Tea Party, because you take away the power of the IRS to make that determination in the first place.
I would reform our civil service laws to return to the spirit of the original Pendleton Act, in which you regulate the hiring to prevent a political spoil system while leaving the government fairly free to fire people for misconduct or firing without this extensive appeals process afterwards.
Thank you. You know, I respect people's suggestions, and again, I want to hear and listen to what those suggestions should be, and we have now had some 45 transcribed interviews, some 250 employees from the IRS, some 700,000 pages of documents, and the IRS, at taxpayer expense, has spent over $18 million responding to congressional inquiries. But yet, we have not, as a committee, taken action on anything. But we continue to have these hearings where allegations about White House involvement is alleged. You know, from the very beginning, when the chairman first started this process, when the Inspector General first issued his report, it was Chairman Issa who went on national television and said, quote, "This was the targeting of the President's political enemies effectively, and lies about it during an election year." Hal Rogers, the chairman of the Committee on Appropriations, stated, and I quote—
The gentleman's time has expired, but please continue.
Thank you. Of course, the enemies list out of the White House that IRS was engaged in shutting down or trying to shut down the conservative political viewpoint across the country, an enemies list that rivals that of another president some time ago. But after this exhaustive investigation, the committee has obtained no evidence to support these accusations. And so, again, I have asked the chairman respectfully, and to my members on the other side who I have talked with, you know, let's get to the place where we can fix what is broken so that there is no longer targeting and this never happens again. Because there are some of us who have that concern and want to get to that point. But we don't think that it should involve conspiracies and accusations that are unfounded, not after $18 million of taxpayer investment has been wasted. I yield back my time.
I thank the gentleman. I might note for the record that long before I made those statements, I suggested that the White House would be well served to hire accountants rather than attorneys, but they didn't take my advice on that either. Mr. Meadows, would you like to be next up? The gentleman is recognized.
Thank you, Mr. Chairman. I will be very brief, but Ms. Mitchell, I want to come back to you on a couple of areas, because one thing that was troubling to me as we went through 12 hearings, was that the IRS early on said that if you were applying for a 501c4 status, that there was a waiver, kind of an exemption, that you really didn't have to apply. And out of the people that you've represented, or the ones that you know that have been represented that were caught up in this targeting, how many of them were notified by the IRS that there was this exemption, that if it went over, I think it's 270 days, that, how many of them were notified by the IRS?
Well, actually for a 501c4 application, this is what I'm saying, that you don't have to have a letter of determination from the IRS in order to function as a 501c4 organization. However, if you want to raise money from the public, and you have to file charitable registrations in 38 states, and those states all require a letter from the IRS or a copy of your application that you're trying to get one, which is why I think we ought to eliminate the process. So, but there's the 270-day threshold only applies to 501c3s. Once you apply as a C4 or 5 or 6 or 7 or 8 or 9, you are at the mercy of the IRS to decide when it's going to issue your letter, and you don't have any statutory right to pursue a civil remedy in court. In the case of True the Vote, the IRS and the Department of Justice filed on the day their answer was due in our lawsuit. They said, oh, we've decided to give you your C3 status.
So are you telling me when Mr. Schulman came here to this particular body and said that there was these waivers and they really didn't have to do that, that was at best disingenuous? Well,
what he was saying, as I understood his testimony at the time, and as I said, I thought it was very arrogant, where he said that, well, these groups don't have to come to us for a letter, which is technically true, but if they do, then we can ask them whatever we want to. That was the position that he took before this committee. And I thought at the time that that was actually, that ignored the rule of law, because there are standards and there are application and instructions, and they shouldn't be able to go beyond the four corners of that. But there's one other exemption waiver thing that I think that you might also be recalling. You will remember that when Interim Commissioner Werfel went before Ways and Means in June of last year, he told the Ways and Means Committee, and they sent letters to all of those whose applications were still pending, that had not, all the Tea Party groups who had not gotten their exempt status, waiting for all this period of time, hundreds of them, and several of my clients, and they received letters from the IRS saying, if you will promise that you will never engage in more than 40% political activity, and if you will also promise, and they threw in there a ringer that said, counting not only your program expenditures, which is what the law says, but they threw in, as I say, they've abandoned the rule of law, they threw in this other category of counting volunteer activity. Well, how are you supposed to do that? There's no standard, there's no, and I told several clients who said, what should I do? I said, well, I don't know how to tell you to answer that, because you're going to have to sign under penalty of perjury from now on that you're complying with something that has no legal definition.
Well, what it sounds like, we've talked about banks that are too big to fail. It sounds like the IRS has gotten too big not to fail. Would you agree with that?
Well, that's why my #1 recommendation is that everybody ought to sign on to Congressman Jim Bridenstine's House Joint Resolution, 104, to abolish, to repeal the 16th Amendment, abolish the income tax, and get rid of the IRS, because I think it's become the tail wagging the dog of our country, and I think it's a detriment to our nation.
All right. Mr. Shirk, let me go to you from a labor standpoint. One of the frustrations as a business guy, I sometimes call the government the big easy, that once you get here, there's no way that you get fired. Would you say that after someone has been with the government for 2 years, that the chances of them getting fired are slim to none?
They are incredibly minuscule. It's like I said in my testimony, once you've passed that probationary period, your odds of getting fired are 1/4%. So,
how does that compare to the private sector?
So the private sector monthly, the best we know from the Bureau of Labor statistics is they have a figure for both layoffs and discharges. So both we fired you for showing up drunk, and we fired you because we're losing business. It's not strictly comparable to the to the Federal Government because, of course, the Federal Government doesn't go out of business in the same way private sector companies do. But that monthly layoff and discharge rate is about 1.3% versus an annual termination rate for performance and misconduct rate of basically 1/4%. So it's the monthly private sector rate is 5 times greater than the annual Federal rate.
So a fraction of the private sector.
Exactly.
I appreciate the patience of the Chair. I'll yield back.
I thank the gentleman. We go to the gentleman from Michigan, Mr. Bentivolio.
Thank you very much, Mr. Chairman. Ms. Mitchell, thank you very much for all the work you're doing. God bless you. As a Tea Party Republican, I'm a big fan. And since this story broke, thanks to you about the IRS targeting Tea Party groups and conservative groups, a number of people have come to me back in my district saying they believe that they've been targeted because of their political beliefs. Working as a school teacher that's run by the Michigan Educational Association, auto dealers that lost their dealership at GM and Chrysler during the bailouts lost their dealerships not because of their past performance, but because the dealer owners donated to Republican groups. And now there are churches. I'm hearing some people that are have to go before the IRS and explain what they're doing in their church regarding their political activities. Have you heard of any other groups being targeted because of their political position?
Well, as I said in my testimony, I think that this is something the committee really should investigate, and that is I have heard repeatedly from Romney donors across the country that they were subject to personal income tax audits by the IRS, or their businesses were subject to audits. And I just have a sense that it's too common to be, it's not scientific. I've spoken with TIGTA about it. I think that it's really important that the IRS answer the one question: have you ever used campaign finance reports and donor information to target individuals for IRS audits? And I think they should be forced to answer that question. And then you have to then ask, did you do it equally to donors to the Obama super PAC as you did to the Romney super PAC? Because I think that this committee needs to get to the bottom of that, and because I really firmly believe that that's been going on, and I think that that should be made statutorily illegal.
Thank you very much. Once again, thank you for all that you do. Mr. Chairman, I yield back.
Would the gentleman yield to me?
Yes.
Briefly, I just want to get one thing on the record that we haven't talked about, and I know Mr. Horsford was interested in the reforms, but he didn't stay to hear them, nor apparently read what we put out on the suggested reforms. But, Mr. Keating, we already previously made clear 501c4s get no tax exempt, you pay with after-tax dollars if you want to belong to that affiliated group. What's the best way for people to understand the history of anonymous giving to groups that represent them in some cause? Call it political, call it ideological, but isn't there a long history of the Court looking at people's ability to have anonymous free speech through association so that they not be ultimately persecuted for their attempt to bring some form of justice? Can you give us, either of you, give us some of the history?
Well, probably the most famous case that people are aware of is NAACP versus Alabama. And obviously, back in the 50s, the state of Alabama was not that keen on the types of recommendations being made by the NAACP, and they sought to get their membership list and presumably their donor records as well. And this case went up to the Supreme Court. The Supreme Court said the state had no right to get that information under the circumstances designed in the law. But this is not the only case. There's another case that I'd like to cite. I believe it's Talley, but I may be getting the name wrong. There was an ordinance passed to require labor organizers to register or display names while they were trying to organize. And the Court, again, said there's no right for the government to force that kind of disclosure. I
suspect that the tag should say "hit me" in the anti-union movement, potentially. So, I mean, that clearly you would have been sectioned out. That was a way to go after the union movement if they would have been allowed.
Absolutely. And, what we point out is the purpose of disclosure is to allow citizens to monitor their government and to monitor government officials. The purpose of disclosure shouldn't be for government to monitor the citizens or for people to use that in coordination with the people in power to monitor citizens or harass citizens for their political activity.
So the history of anonymous free speech, of the right of people to associate and to associate in a way in which their ideas can be put forward without retribution, is in fact not a conservative history. In many ways, it's a progressive history of the court finding on behalf of the American people that right, isn't it?
Absolutely.
Thank you. With that, we go to Mr. Woodall.
Well, thank you, Mr. Chairman. I was just watching it on TV back in the office, and I was so enjoying everybody's answers and solutions. I thought, I want to come and see it in person before folks leave. I don't want to slow you down any further. You represent, well, I came up in that big freshman class of 2010, and you represent the pulling on the rope that so many of those members from both sides of the aisle, that inspiration that brought them here. The Heritage Foundation has been the touchstone to which folks have looked not for blame, but for opportunity to make a change for a decade upon a decade. There's no one else who has played that role better. Ms. Mitchell, your name has come up. I won't tell you for how many years your name has come up in my readings and dealings. I didn't have to get any further than the first page of your testimony, where you said the secret is just to repeal the 16th Amendment, and then we could solve these issues. You had me right there. We were committed. And of course, Mr. Keating's been in this business a while, trying to pull on the rope and make a difference. Candidly, I'd never thought about why it was post-Watergate we decided that the executive branch manipulation of the IRS was a bad thing, but if Congress wanted to manipulate the IRS, maybe that'd be okay. That makes no sense whatsoever. While Ms. Mitchell's recommendation to repeal the 16th Amendment would solve it better, prohibiting Congress from manipulating it would certainly make a difference. I, too, heard Mr. Hersford ask about what the solutions are, which is the question I would hope 435 people want to ask. But if you guys are not doing what you do, we never get around to the asking of the question. I can't tell you how many conversations I had where folks said, oh, the IRS would just never do that. That could never happen. This is America. This would never happen in America. And until somebody cares enough, Ms. Mitchell, to make sure that grievances get heard, you think it could never happen in America, but it does. And without the think tank, without the watchdog groups, we are lost. I looked at your testimony, and I thought, golly, where are the liberal witnesses on this panel? And I thought, you know what, this is not really a conservative or a liberal issue. Free speech, without it, neither of us could persist. So I won't delay you any longer. Just know how much I appreciate what it is that you do. I can't tell you how many conversations we've had in this freshman class of 2010 that say we want to make a difference, but it's so hard to figure out how. Sometimes you all don't have a voting card, but you have a long list of resources and an endless amount of passion that folks who do have voting cards look to try to make a difference for families back home, and I'm grateful to each one of you for that. Mr. Chairman, I yield back.
I thank the gentleman. Now, this may come as a surprise, but I never asked my first round of questions, so I'm going to sort of finish by asking. We made a number of suggestions in the document we put in. It was provided to all of you. But there's more than one way to skin a cat, is an old expression. Are they equal, acceptable? Would they all be improvements, is a general set of questions. Mr. Shirk, you looked at what we did in the way of civil service reform last week. Was that a good start?
I think it's certainly a good start. It's a move in the right direction. I think, though, that you need to move beyond the SES, that a lot of the employees engaging in misconduct are not the managers, but the rank and file. And if Congress isn't going to wholesale overhaul the the civil service protections, things like allowing people to be immediately removed without pay instead of waiting for 30 days, things like extending the probationary period, and really just making it, reducing the number of appeals that employees can have. That's what really gets the agencies upset, is that it's, the in-house review, okay, that's one thing, but then when it goes to the Merit Systems Protections Board, then they appeal to their headquarters, then it goes to the EEOC, and then it goes to the courts. Just pick one forum, and only one set of appeals. Don't get to relitigate it time and time and time again, so it drags out over a course of years. I think would make the Federal managers more willing to use those procedures.
Well, one of the suggestions that's been made, and I want your opinion on it, is that people have to choose to either be members of a union and come under that union contract protection, or civil service, but not both.
Well, it sort of works that way now. So you can either use your union grievance procedures, or you can use the Merit Systems Protection Board. So to that limited extent, you've got one forum. But then at the end of either the union grievance, the arbitration, or the MSPB, then you can appeal to the Federal courts. Then you can, if you're alleging discrimination, you can appeal to the EEOC. And I think you should have to pick one. If you're saying you're fired for discriminatory reasons, appeal to the EEOC right at the beginning. Don't go through the grievance, then go to the EEOC, then go to the courts. Just pick one forum.
Now, on another subject, the question of should there be one commissioner or a board? We put that out. I think I'd get a general agreement that you think that the normal commission process, where you have a bipartisan commission of some sort, whether it's 5 with the chairman being the party of the president, such as the SEC and so on, or 6, such as the FEC, where it's truly an equal board. You all think that would be an improvement over the current commissioner, who is strictly a political appointee of the current president. Is that right?
I certainly agree with that, and I speak from experience as a commissioner at the FEC. I mean, the whole advantage of having a multi-member commission is that the board has to work to try to reach consensus on issues. And therefore, if something comes up on an enforcement question, a regulatory question, a policy question, you've got people with different points of view raising issues about it. This is particularly important, quite frankly, to have members of both political parties there.
So your point would be that by having a multi-member commission, when they all agree, American confidence is much greater than when the political appointee of one party makes a decision.
No, that's exactly right. And frankly, look, when they disagree, for example, look, there are rare occasions, it's actually a very small percentage, despite what people may believe, when the FEC, which has 6 commissioners, will disagree 3-3. Well, if they're disagreeing on the interpretation of a regulation, then it's probably a good thing that that regulation is not going in place. Because if the 6 commissioners who are tasked with enforcing the law disagree on what the law means, then you shouldn't be forcing that on the public to try to comply with a confusing regulation or confusing law.
Now, there's a suggestion that we remove the political question entirely from the IRS, which means that, for example, with a 501c3, the question of deductibility would remain at the IRS. However, whether the American Heart Association, American Lung Association, the Red Cross, whether they crossed lines of political speech, and if so, what the reporting requirement would shift to the FEC. Is that your understanding? And I said 501c3 for a moment because we've only talked about the C4s and other corporations. Would it be the same for 501c3s in your interest, or would there be a legacy there?
I think there has to be a difference. The statute specifically says a 501c3 can engage in no political activity at all.
I agree with you, except that the precedent is, yes, they can and they do. It's been limited to, quote, de minimis. The American Lung Association actively supports laws that reduce smoking, and they campaign on television supporting the establishment of, let's just say, a vote to ban smoking in public places. They do that. The question is, to the extent that there is any activity, who should regulate it? And I ask that for a reason. Inevitably, free speech becomes political by somebody's interpretation. Now, there's not an R or a D after, clean air. There's not an R or a D after smoking and non-smoking. I've noticed people of both parties will choose one side or the other. So it's not partisan per se, but the question is, should we transfer entirely to the FEC any and all responsibility for compliance with any and all laws related to political activities?
Well, generally, I think for any other 501c organizations other than C3, where there's a prohibition on political activity, and by that I believe really means express advocacy for or against a candidate, not for or against an issue. I don't think there's any.
So as long as that definition is maintained, you're comfortable with the 501c3s as they are, because their ban would be absolute, and thus it's not a judgment call.
Right, although I do think the rules there need to be clearer as well.
I appreciate that. Let me ask one more question, and it goes sort of like this. If we were to move political oversight to the Federal Election Commission, consolidate in one place with one expertise, and Ms. Mitchell, as you said, with a consistent definition, which would certainly be helpful, then would one of the reforms of the IRS be, as we said earlier, a multi-member commission, or in the alternative, if Congress in the process felt that a commissioner did not serve at the pleasure of the President, but rather, like the FBI director or the Fed chairman, served a tenure that was longer than a particular president and thus had a level of freedom, would either of those, in your opinions, be an improvement? Not saying you're picking favorites, but just would either be an improvement over the present situation in which you have an overt appointee of the President who is beholden to the President every day for his or her appointment? Ms. Mitchell.
Well, I think either of those would be an improvement, but I would certainly caution that that reform, absent some of these other statutory changes, will not be sufficient to reinstate the rule of law at an agency which has essentially gone rogue. Lois Lerner talked about rogue agents in Cincinnati. The agency itself has gone rogue, and there is a real need for, and that's one of the reasons that I'm so grateful that this committee is conducting oversight of this agency, intensive scrutiny of this agency. Yes, it may be uncomfortable, it may be expensive, it may be time-consuming, but this agency is out of control. And I'm sure every member of this committee, Democrat and Republican, has heard horror stories from constituents about the IRS. And Congress has got to reassert its authority over this agency because it feels as though it is capable of completely thumbing its nose at the people's representatives. And I don't care what party affiliation, I would be very offended by that if I were a member of Congress. I certainly am as a taxpayer.
Thank you. Mr. Davis.
Thank you, Mr. Chairman. I want to make sure that the record is clear regarding the publicly released notes regarding the July 2010 screening workshop for IRS employees. Contrary a bit to what Ms. Mitchell has said, although it says that, and I quote, progressive and Tea parties are not the same and should not be sent to the Tea Party coordinator, the notes direct IRS screeners to treat Tea Party and progressive groups the same. It says, and I quote, current political activities, discussion focused on the political activities of Tea parties and the like, regardless of the type of application. If in doubt, err on the side of caution and transfer to 7822. Indicated the following names or titles were of interest and should be flagged for review: 912 Project, Emerge, Progressive, We the People, Rally Patriots, and Pink Slip Program, end of quotation. I ask that these notes be included in the record.
Without objections, order.
And I might also note that, it's interesting to have political ideologies and philosophies, But I also note that the IRS Commissioner, as well as the Inspector General, who were in place as these allegations surfaced, were both President Bush appointees, which sort of would indicate to some people that they may have had some Republican leaning, although not necessarily so. But that would appear to be some type of implication. I also might note that the Inspector General, while he or she cannot change law, they can make recommendations. And this Inspector General made 9 recommendations, all of which the Internal Revenue Service has complied with and gone beyond. And so I think it's an indication that the Internal Revenue Service is moving progressively to try and make sure that it improves its operation and that whatever happened in the past is not necessarily what is going to happen in the future and is not what's happening now. And I know there are people who would not like to pay taxes, and so they'd like there not be a mechanism for which to collect. But I doubt very seriously we have difficulty agreeing on very minor things around here. So I doubt very seriously if we would reach that point.
Well, I think, Mr. Davis, I'd love to see the fair tax, and then we could go on from that. And I know Mr. Woodall, would that be an amen from the front row up there?
Well, I think we'll be working on taxation for a long, long time. And I want to thank the witnesses for being here. I want to thank the chairman for holding this hearing. And I yield back.
Thank the gentleman. At this time, the Chair recognizes himself for questions, and just a few questions here. And I just have to say, on a point of personally, Mr. Scott, your book, Obama's Enforcer, you actually detailed one of my inquiries with the not enforcer in chief, I think the obstacle in chief a lot of times for this administration. And I think it sort of shows, frankly, it's very disturbing. I think it's sort of been developed over time in many of these agencies. There's just a disdain for coming up here and having Congress do its normal oversight role. We may disagree, but there is a role for both to play, and I do appreciate that. And between you and Ms. Mitchell, I have a question. Tea Party tax-exempt applications experienced significant delays when they were in the determination process, with some waiting years to hear back from agencies regarding their status. These delays cause the groups to lose support and funding and can even cause them to disband. Therefore, to me, it's worth considering proposals to streamline the IRS tax-exempt application process by implementing a time limit to evaluate applications. What are the consequences of an IRS delaying applications of these potential tax-exempt groups, and then also what your thoughts on a timeline would be?
Well, it's very detrimental to these organizations, and particularly most of these organizations are not the Karl Rove type groups. I mean, these are mom and pop organizations. They're small citizens groups that operate on very small budgets, and the cost to them of the delay meant people thought, well, maybe they weren't legitimate, so they couldn't raise money. For some of the larger groups who were trying to build a network that they could help then smaller groups, then they would run into trouble with the state regulators because they didn't have letters of exempt status. But my basic belief is that we should just eliminate that application process altogether, and then you just get rid of it. Then there's no temptation. You just let a citizens group file, say I'm a 501c4, I'm a 501c5, I'm a 501c6, whatever, just the same way you do for any other entity in America. To open a bank account, you get an employer ID number, and then they file their 990s, and then the IRS can, on a random statistical basis, not on a basis of selection based on political philosophy, but on a random basis, be able to look at organizations and look at their operations through their Form 990s and look at their programs after the fact, after they've been operating for a few years. But what the IRS did here through this application process, and which they've said they're going to continue to do, This is the part that I want everybody to understand. The IRS said on March the 4th of this year they're going to continue to do this. And it's in their guidance. It's not in any regulations, and they buried it at the bottom of a newsletter that about 4 of us received, and that I read at 3 o'clock in the morning because I was waking up and couldn't sleep. And it says they're
Not the
going to
most open
continue
and
to do this.
transparent process there.
No, and they're going to continue, and they're going to try to look at, the questions that they're going to ask applicants presuppose that these are organizations that have been operating for 2 or 3 years before they can answer the questions. So we just need to make, here's clarity, abolish the process. Here's clarity, define political activity for all purposes, for whatever agency is doing it, whether it's FEC or the IRS, as expressly advocating the election or defeat of a clearly identified candidate using words such as support, oppose, elect, defeat, vote for, vote against. If we did that, we would clarify. That is clarity. And that's the kind of thing that we need to have Congress do.
Yeah, no, I totally agree with that. I think you should eliminate the IRS having to approve an application. If Congress doesn't want to go that far, I mean, this fallback position is to put in a time limit, give the IRS 60 days to approve it. And if they don't approve it in that time, then it automatically becomes approved. There's certainly precedent for that. A 60-day time limit, for example, was the time limit imposed by statute and regulation on the Department of Justice under Section 5 of the Voting Rights Act. So there's precedent for this, and that's the way to do it.
Well, and I think that again, is fairness for all. Let's just make it simple. Let's make it a process. If you're doing wrong, you'll get fixed, and that's the catch process, not the front end that seems to be such a problem. One issue I think that is just stuck in the craw of most Americans that they just don't figure out. And and Mr. Well and I from Georgia, we get this question all the time. It's why somebody, either one, can't be fired. This is been an amazing discussion that we've had in this office before, in this hearing room before. But when Ms. Lerner left between May 13 and September 13, she collected full pay and benefits, and roughly 60 to 100,000. That was her annual. At what point does there also need to be personnel changes or personnel issue development in the IRS, and possibly a bigger speed? Mr. Keating, anybody want to tackle that in my last little, as we finish up here?
Well, I'd just like to say that we've got a horrible system that makes it very difficult to remove government employees for any reason. I think Congress quite sensibly didn't want to have a lot of these jobs handed out on the basis of political connections and should you help with the campaign. But we've gone way overboard where you not only regulate the hiring on a merit basis, which I think is quite reasonable, but make it very difficult to remove employees. I mean, I outlined, if you just stay within the Merit Systems Protection Board process, it takes an average of about a year and a half from start to finish, from when a supervisor says, I want to remove a problem employee, to when that level of appeals are done, outside of any appeals to the EEOC or to the Federal courts. I mean, it's when the Office of Personnel Management says that managers describe the efforts needed to remove an employee as, quote, heroic, then I think we know we've gone too far.
Right. I think protection needs to be there, but at the same point, it shouldn't take almost literally an act of Congress to do something. Well, I think what we're seeing here is an interesting. I think the hearing has been, I think, something to discuss the fact that there are many problems here. But I think the one thing we can all come to a conclusion is, I told the Commissioner of the IRS when he was sitting here just a little over a week ago, I said, you've lost the trust of the American people. It was never the highest in the world, but just by basis of what they did. But we've now lost the trust in everything. It doesn't matter how much work we've been in, because, as my friend Congressman Davis said, there is a tax system. There is a collection system right now. We may not like it. We work to change it, but this is a system. And when you've lost trust in the very ones who are supposed to be actually enforcing that and taking that in, that's a problem, and the people aren't satisfied with that. With that, I'd like to thank our witnesses for taking their time out of their busy schedule to appear before us today. And with that, the committee stands adjourned.